Hello everyone, welcome to my fabulous home question and answer session on land matters. Today we shall be receiving some answers from a team of young lawyers. I'll ask them to introduce themselves.
Hello viewers, my name is Laoko Jordan. I'm a partner at Bitelex Advocates. I do a lot of land transactions and land deals, and I'm happy to be on this panel today and share with you and answer also other questions. Yeah.
My name is Irene Eyojide. I'm a partner at Bitelex Advocates, and I'm glad to be here today to be able to answer all your different questions in relation to real estate and land rights.
Thank you, everyone. My name is Itogot Amy Amina. I'm a member of the Network of Public Interest Lawyers. The Network of Public Interest Lawyers is a union of different lawyers, law firms, and organizations that are interested in public interest litigation. And through public interest litigation, we help people to achieve social justice. Now, in the NetPIL, we call it NetPIL, is the union behind the recent court judgment of James Mohindo versus Attorney General, whereby a public interest litigation case was lodged, and it was compelling government to come up with eviction guidelines. That case was stating that the eviction of people without proper guidelines is a violation of their right to life. So that's the case that NetPIL is behind, and government and the court agreed with us, and government has been compelled to come up with eviction guidelines. Thank you so much.
Okay, thank you so much, Amy, Irene, and Jordan. We shall go straight to the questions. Our first question is from Judith Okech, and Irene will be answering the question. If I am a Chibanja owner or holder, what key processes can I embark on to process a land title?
Yes, Judith, you wanted to know about the processes to process a land title, and also as part of your question, you wondered about the limit on the rights of the landlord. So I am answering this question on the assumption that you are a Chibanja holder for someone who has a land title on private Milo. Now, in that case, it is not possible for you as a Chibanja holder to process a land title, because that means that your landlord already has a land title. And you will normally hear the brokers make a distinction between buying a Chibanja and okugula mutaka. So the landlord is the one who has the interest in the land, and he's a registered owner. You would not be able to process a land title except with the consent of that person. Now, if you're able to get the consent of your landlord, what would be involved would be the same as if you had a subdivision. In that case, you'd be required to get mutation forms. Those are just forms that show what part of the land you're going to be taking. Mutation forms and transfer forms signed by the landlord in your favor. Then in addition, you would need to conduct a survey. Means you need to get a land surveyor to do actual measurements and put mark stones on the part that belongs to you. And with that, the surveyor would be able to help you, or if you have a lawyer, would be able to help you get a deed print for your part after completing the subdivision. And then the land, using the transfer form signed by the landlord, you would transfer the land into your names. That is the process of getting a land title. For anything that may not be very clear, you can still inbox and ask for further clarification.
Can I bypass the landlord to get a land title using a sale agreement because the landlord is not cooperating after 5 years of me buying the land and asking him to assist me get a title?
Yes, Mr. Ngobi, that's a very interesting question. Ordinarily, at the point of contracting or when you are making your agreement, there are certain formalities you should have done to, safeguard yourself against such a long delay of the landlord, transferring to you the title. For example, you should have maybe talked about the time limit in which you get you the title, should have asked for a copy of the mother title, mutation forms, as Irene here had previously discussed. But all hope is not lost in the circumstances, because when you contracted, you acquired a right to that land, equitable title, and now what you can do, assuming that you're having a private Milo title, or maybe you're on a freehold title, you can go to court, you sue for an order of specific performance, where the court will order the registrar, or even like the landlord, to go ahead and follow the processes, these processes here, or you can even dispense with the authority of the landlord and go direct with the court order to the registry, and then they cut for you your portion of your title. Yeah, that's it. Under
what circumstances can one safeguard themselves under customary ownership of land, which areas in Uganda are not surveyed yet? Can the condominium idea work in such cases of customary ownership of land?
I would like us to first understand what customary ownership of land is. Customary land is land that is held according to the customs and norms of the people. So largely, most of that land is not registered. And in our country, Uganda, 80% of the land is held under customary. So it is not registered land. So how you can safeguard yourself, I would advise that the best thing is to move into the registration process and move to get this land registered, so that you can now get a title for the land. Then secondly, when you ask about it being safeguarded as condominiums, condominiums and customary land are two different things. Condominiums are more of like apartments where someone is building up, and the law wants to give those people who own those particular apartments, probably on the next block, on the other block as you're going higher, to be able to own titles for those particular apartments. So customary does not apply in terms of condominiums. Condominiums deal with registered land. So I would advise you to get into the process of registration of that land, so that you can finally get a title. That is the best way you can be protected. When you have a title, you can be able to take it to the bank and get a mortgage. You can be able to use it as security. It gives you that sense of protection when it's documented and you have that title. Thank you.
Najit and Eloy wants to know, recently our landlord sold land to a new landlord who requires us to get a title. My chibanja is less than 50 by 100. What should I do?
Loy, you say that your chibanja is less than 50 by 100. So that would mean within the land registry, you may not be able to get a title. The minimum sizes of the plots that are now allowed is 12 decimals for the rest of the country. But for Kampala, I'm aware that it's at least 15 decimals for you to be able to process a title. So that would mean you're in a difficult position, being that you can't get a title. Although I'd want to reassure you and say that the landlord cannot force you off the land because you're not able to get a title. The landlord provides that anyone who buys land and is aware of other interests that may be adverse or that may be existing before his own interest is bound by those interests. So in the same way you had the right to stay on the land with your old landlord, even with the new landlord, you still have what we call security of occupants. You can stay on that property and you will not be evicted by the new landlord. In the alternative, if you're able to maybe enter into an arrangement with a neighbor, because also in your question you indicate that there's no room for expansion, if you're able to enter into some kind of arrangement with your neighbor and get maybe get registered as joint owners, specifically as tenants in common, and that agreement would specify which part of the land belongs to the other. That is if you must get a title. But for now, with the current size of your land, it will not be possible to get a title from the land registry.
Faith wants to know, someone was buried in your land and needs to remove and bury the remains in his plot. What processes does that person need to follow?
This is a very interesting question. It has a lot of legal and policy considerations that underlie this question. Because first imagine a situation where people just transfer bodies, from plot to plot, or like you want to buy land, then you find bodies, you just want to, move it and take it to another place at your own recourse. It's not allowed. When you look at our criminal laws, you understand that there's an offense for, disturbing the dead. This may not apply directly here, but for you to safeguard yourself against any potential criminal liability or any civil disputes that may arise because of this circumstance, it's advisable that you go to court and then you get a court order allowing you to exhume and then transfer this body to where it's supposed to be. Go to court, get your lawyers, get a court order. Then following formal procedures, there are people who are trained to handle these situations. They remove the body, then they transfer it where it's supposed to be.
Okay, maybe Jordan, before in that process, aren't you supposed to have a discussion with family members who maybe originally put these bodies here?
They may have some culture.
Yes.
Of course, I was just looking at it from the legal point of view. But of course, when you're in a society, there are people who exist in that society. You may go and have a discussion with them, but if they do not heed to your discussion, then you go the legal way. You can exhume that. As long as you have the order, you have the authorizations to do that, then you inform them that they can take the body wherever it has to be buried.
Our next question will be directed to Amy. It's from Catherine. And she wants to know, my husband sold off our family home without my knowledge, and he left for Sudan to do business, but has never come back. When I was staying in the house, people came to evict me. They successfully evicted me and the children. However, I want to get back the property. What can I do?
Sorry about that, Catherine. That is really sad. But the good thing is that there is a recourse for you in the law. Under the Land Amendment Act, the law was amended to protect spouses, a spouse. That also entails a man. Yeah, so in a situation where your spouse sells the land and it's your family land, because the law defines family land as the place where you ordinarily reside and also the place where you derive sustenance. For example, if it's a farm, or the place that you agree that shall be family land. So in this case, this kind of land that was sold falls under family land because that's where you've been ordinarily residing. So in this situation, as a spouse, your spouse was supposed to obtain your consent. And the law says that any property, family land that is sold without the consent of the spouse, then that transaction is totally void in law. So when a transaction is totally void in law, it means the spouse can sue and then court can, give you a declaration that you get back your land and then it can be enforced. So you have that right. You can be able to sue. You just need to get a good lawyer who can be able to institute for you those proceedings, and then you're able to recover your land. And if you're not able to afford a lawyer, there are organizations like Uganda Law Society, Legal Aid Clinic that can help you to be able to get back your house so that you're able to be happy.
What is the cost of processing a 50 by 100 title for a plot?
Yes, I'm going to assume that this land has not yet been surveyed, or it's not yet registered in anyone's name. So I'm going to start right from the stage where you bought your plot from someone, maybe in a place where they had a big chunk of land, but they have never had it surveyed and titled. So in that case, the first step would be to get a surveyor and let him carry out a survey. Your major interest indicates that you would want to know the specific costs. So most of the surveyors I have worked with will need at least, okay, the ones I've worked with will need at least 2.5 million to do the entire survey process. That's the least amount they will ask you for to be able to get you the survey deed prints, from which process, after doing the survey, you can embark on the title processing. Now, the title processing involves printing out of the title, because by that time, they have already assigned it a plot number, and they're already aware of who the landowner is. So depending on where the land is located, if it's located in Kampala, you'd go to the KCCA Ministry Zonal Office. If it's located in Wakiso, you go to the Wakiso Ministry Zonal Office, and likewise for the regional Ministry Zonal Offices. So you would be able to get your title printed out. The official costs include registration fees. There's a fee which is called assurance of title, and there are some other additional fees. But on the whole, the official fees will not go beyond 100,000. Although I must be honest that to follow the normal process may not be entirely possible, because that means it would take you a very long time to get that title. So you wanted to know the exact details, so I'd advise that you get someone to follow it up for you, which person will also need to be paid to make sure the transaction is concluded within a good time. In addition to all those costs, so those costs would maybe come to about 3.2 million. So in addition to those costs, you'd have to pay professional fees to the lawyer who's doing all these processes, and I cannot give you an exact cost for the lawyer's professional fees, but the fees, you should anticipate or budget for fees for 800 and above to help you conclude that process.
Our parents died and left property. Our brother was registered as the administrator, and we heard that he sold off the property. What can we do to get the property back? Did our brother have the right to sell?
These are very common cases, especially here in central Uganda. At least I've encountered a couple of them, and even there are very many cases which deliberate on these issues. Now, your brother was appointed an administrator under the Successions Act. That's a succession law of Uganda which deals with management of estates of deceased people. And he was given certain specific powers under the Act, which include, among others, to make sure he administers the estate in the capacity of a trustee, to look out for the interests of the other children and other people who are supposed to benefit from that estate. In the circumstance, he sold it without the knowledge of the people who are supposed to benefit from the land. So in law, he has actually breached his duty. So the first thing which you should do is get in touch with your lawyer and apply to court to have that authority revoked. That's just one leg of the whole discussion. The next thing is to now maintain a suit to recover that land, which could be one founded in fraud to the people who are sold that property, including your brother, because by the mere fact that he did not consult you the people who are supposed to benefit from the land, means there was a dishonest dealing in the circumstances, and he took advantage of the whole situation and the power which was conferred onto him, and sold the property for his own personal benefit. So two things: get the lawyer, have the letters of administration revoked, and also he should declare an inventory of all the properties he has managed in the estate to see what is still there and what is not there, and then you can try to recover all those other things, because probably he has sold even more than the land and other things too.
I'd also advise that in the interim, before you go into the long court process, which I must confess to you would take a while, you need to lodge a caveat to prevent the current owner from selling it to other people. The reason I'd advise that is that any other person buying from the current owner may not be aware of the circumstances under which the land was sold. And because of that, they could be protected from the reach of the law because they are considered to be bona fide, which means they had good intentions and good faith at the time they bought the land. So to avoid that happening, lodge a caveat so that everyone who attempts to buy the land can when they conduct a search, they will be put on notice of the fact that there is an issue surrounding the ownership of this property.
We noticed that these are very common scenarios nowadays where people are given property to administer and then they sell it. Yeah, so for someone who has not yet got into that situation and you're just still in the process of processing those letters of administration, I think it would be advisable at least to have 2 administrators, because in that situation then it becomes hard for one person to do it. They will need the consent of 2, and by the time it is happening, you will get to know. When there are 2 people, most likely you'll get to know compared to when it's one person. So if the family is big and maybe you're not very sure of the one person, it would be advised, if you have not yet got into this scenario, for those who are just still going to process, to have at least 2 people. It would save such a situation.
I bought land in 2017 from a man who I knew was single. However, later on, a lady came to me saying she is his wife. They wedded in 2018, but they had an introduction in 2017. She showed me photos and the Uganda certificate showing they had that introduction. They were using the land for farming. They have since nullified my purchase of the land before court and have not refunded my money. What can I do? That is from Dennis.
Sorry about that, Dennis. That's quite sad. It seems like it was a conspiracy. Sorry about that. Yeah, so what I would advise you is that court was right to nullify the sale, because when a spouse is there and their consent has not been sought, then that transaction is totally void. It's so sad that you did not have notice, or you didn't know that that spouse actually existed. But under the law, there's something we call a bona fide purchaser. If you didn't have notice and this situation has come up, what you can do is you need to sue. You need to sue the seller, the husband. You need to sue the seller to be able to refund you the money that you paid, which we call in law consideration. So you have a right. All you need to do is get a lawyer or who can help you institute those civil proceedings, and then you sue the seller. When you sue the seller and all those facts are brought out and even the other court papers are attached as part of the evidence, most likely court is going to order them to pay back the money that they took. And it's so sad that these things are happening. They are happening a lot. Yeah, most times there are those situations where spouses are conniving to do that to people who they want to sell land to. Most likely it's like they're trying to get a loan in some way or the other. They want to get money, so one will sell to you the land, then the other will not appear. You will not know if they're single or not. Then later they come up to get back their land. It's so sad. And in this situation, you can still get back your money.
Maybe before we go to the next bunch of questions, we've had these discussions and we are talking of suing or seeking legal assistance. Just in case I don't have the capacity in terms of finances to hire a lawyer, is there any remedy for me? Can I get legal assistance anywhere without paying? For example, if I can't afford, and where exactly can I go to get such legal assistance?
Okay, in such a case, the Uganda Law Society, which is the body of lawyers, organizes what we call a pro bono scheme. That's where they're able to offer legal services for free in respect of any matter. But before you're eligible to benefit under that scheme, it must be clear that you are completely unable to afford. Because I may say this and people will run to the pro bono scheme hoping that they can get free legal services. That legal service is available for people who are not able to raise the money to afford the professional fees. So what Uganda Law Society does is it will cover the costs of the lawyer, but then the lawyer who is signed onto that scheme is willing to handle the matter without being paid fees. There are also other pro bono schemes like justice centers. There's another one called legal aid. So any of those different organizations should be able to avail you with services. You visit them, and if in their assessment you're a suitable candidate to benefit from their services, they will help you.
I think also Uganda Christian Lawyers Fraternity offers legal aid to people who have, suffered and then they're in those situations. But you have to be eligible, like Irene said, because it would be strange for you to come with a sale agreement of 50 million and you're out seeking legal aid. So Uganda Christian Lawyers Fraternity, UCLF, is located in Wandegea on Baptist House. That's where they're located. So you can seek them out, you can search for them online, and they can be able to help you.
My dad and mom have been married for 39 years in a traditional marriage. They have been in court 2 times, and my mom 1. We caveated the land last year. Is it enough to protect the interest of my mom?
Okay. First of all, it's a good thing that your mom won in both courts. That means, as far as she's concerned, there's a court order that clearly indicates that she was legally married to your dad and that she has an interest in the land. So, as far as that is concerned, you're covered. In regard to the caveat, there is a provision in the Registration of Titles Act which says that which provides a particular number of days after which the caveat shall lapse. Now, because of that, a caveat is only a temporary solution. You put it when you're suspecting someone is going to do an arbitrary thing, and that thing would affect you. So, to answer your question, it's not enough for you to stop at the level of caveat, because the other party may apply for removal of that caveat and have it removed because it has gone past the days. What I would advise, since you already have the court order, I'm not aware of the details of the court order and what exactly the court was deciding on. It may have been a divorce petition and they were stating that they are joint owners, or it may have been something in specifically relation to the land, which spells out your mother's rights. So depending on which court order it is, you'd have to take further steps that enable your mom to either be registered as joint owner, or that would enable a direction that can allow a subdivision of the land to allow your mom's portion to be clear. Yes, so the step you take next to create a more concrete solution will depend on what was in the court orders. Then if we're able to look at the court orders, we can advise further on what you should do to finally resolve everything.
I think the person who asked that question had also said they had tried to lodge a caveat, and they wanted to know if the caveat lasts forever. Is that enough to protect their mother? Yes. The spousal caveat, according to the law, it lasts as long as you're still married. So be rest assured that she's covered. You just have to maybe do regular checks with the land office, do a search to find out if the caveat is still on. I think that's what you need to do. And I noticed we've been talking a lot about the spousal questions have been coming up a lot. And I've realized we may need to be clear to our audience on who a spouse is, because it's unfortunate, but under the law, even if you have lived with someone for 20, 30, 40 years, and you haven't been married under the designated kind of marriages that are recognized under the law, then you're not regarded as a spouse. And the kind of marriages that we have under the law, we have the civil marriage, the one that takes place at the registry. Then we also have the marriages that take place in church, but it's also subject to the church being licensed to carry out those marriages and the minister being licensed to carry out those marriages. So sometimes you have to be careful. Someone may take you to a church which has no license and a minister who has no license, and you think you're happily married. Then when it comes to issues of property, you consult a lawyer and they will tell you probably you don't have any ownership of that property because you're not legally married. And the person who took you to that particular place will be the one telling you, but you know, this place had no license. Those are the things they'll be bringing up to actually state that the property belongs to them. So with church marriages, that is something which is paramount. The place has to be licensed and the minister has to be licensed. If the place is not licensed, you gazette the place. You gazette the place through Uganda Registration Bureau, Services Bureau, and then the minister has to be licensed. With that, you then can be a spouse. Then we have the customary marriages. I think I'll give Jordan and Irene to talk about them. Customary marriages according to customs. So if in that custom a kuchala is not regarded as a marriage, just doing a kuchala will not give you rights over property. So many people are getting lied to that once you have a kuchala, you have the rights over the property and you invest together. Then when issues come up, you have no recourse. So and kuchala is not a traditional marriage because the customs do not make it a traditional marriage. So those ones go into specifics of customs, Buganda, Ankole, and different places. Yeah, so, and then we have the Hindu marriages, right? Not very common, but those are also recognized. Then Mohammedan marriages. Those are the marriages that are recognized under the law. Right now, cohabitation has not yet been recognized as a form of marriage, or cohabitation does not give you a right to property as a spouse. So you may need to be a bit careful or legalize those things. Just go to URSB and wait, at least you have your paper there and you're sure you can own the property together. Yeah, so you can comment on customary marriages.
I think you've already emphasized the major thing about customary marriages. The need to go through the entire process. It's not enough that you had one visit at the girl's home. If you had a visit and you never paid the bride price, according to that custom, if bride price is a requirement for you to be married, and that payment of bride price was never waived by the father-in-law or whoever it is the clan head or the family head, then as far as the law is concerned, that function was never concluded and there is no subsisting marriage. So we should take care to make sure that if we are going to rely on a traditional or customary marriage, we try to satisfy the requirement of those customs of that particular culture as much as we can.
Much has been said about the marriages, but I think just for your own caution, before you get married, make sure you get married to a person who is not already married. Yeah, that's it.
We bought land from a company. One director signed. Later, the other director sued us and stopped us from using the land. What are our chances in this case, and how do we get back our money?
They say that land was bought from a company, isn't it? Now, this goes typically to company law in a sense, like how was this land here sold, you know? Because ordinarily, if a company is to sell property, they do resolutions, board resolutions, where directors meet and then they put the resolution that we have decided to sell this land to so and so. And then after that, they certify that and then they will execute the sale agreement. Or else, they could confer rights to a specific director to sell the land. So, as the facts stand right now, we are not sure whether any resolution was put on file or any authority was conferred to a specific director. But nevertheless, there are assurances which are provided for under the Companies Act whereby directors may bind the company. And there's something in law known as the Indo Management Rule, whereby sometimes a person, when they're dealing with a company, they need not inquire so much into the other details. Though in land law in Uganda, you should take extra care and do your own personal due diligence to ensure that you're dealing with the right people, there's the right authorization, and the land was sold properly in a right way. So all facts remaining the way they are on paper, the remedy you may have, the first is to sue the company to recover your money. Or if the company distances itself, go for the practical remedy you may do, just go and arrest that director and then force him to what? To release the money, or sue him in a civil court to get your money back. That's a very practical solution. Otherwise, you may attach both, sue them together with the company.
Then the other question is of someone. I bought land, a friend bought land from Jomai Property Consultants, and we have never got titles till now. What can we do?
Jomai, these are property consultants, isn't it? They buy huge chunks of land and then they sell to different people. You as a buyer of land, of course, you're supposed to do your own due diligences on such transactions. Don't get your lawyers to go down and then you ensure that actually Jomai has title to this property and they sold them to you. I've ever dealt with Jomai before and I kind of know their business arrangement. They go and acquire very huge, chunks of land, and then for economy, because they're also in a business of making money, they delay on processing titles because they want to get as many buyers as possible before they do what? They give you the actual titles to the land, because they do the transactions in volumes. So one transaction at a time may be very costly on them. As long as your interest is okay, you should put a lot of pressure on Jomai, or if you want to go to court, you can sue them for specific performance so that they can process your title early in time and they give it to you.
In this situation, I think we've had so many people complaining. So I think to be able to maybe compel the company to be able to give you your titles, because the questions we've had, some people are saying 10 years, 7 years, and they are feeling a bit unstable. I want to develop my land, but 10 years down the road, I'm not getting a title. I have to get authorization from the district on how I'm going to build. So those issues, I think it would be advisable for you to come together. You gather yourselves, and then you file what in law we call a representative suit, whereby we have maybe X and 30 others. So that can help you with the costs. You pull the money together, and also it helps you so that when court gives the judgment and it's compelling the company, maybe Jomai or other companies, to be able to give you the titles, you're not alone. So that today this one is suing, then that one gets the title, then tomorrow it's better you would look for the different people who are aggrieved, and then you're able to file a representative suit. It can help you to cut the costs. You just get a law firm that can help you do that, then you pull the money together.
Thank you, and we shall be asking Amy still to answer our last question for today. Does the law, it's a simple question, okay, brief. Does the law allow lease of a plot of 30 by 100? If yes, what is the protocol?
I can see emphasis is put on the description of a size of a land, because under the law that size of land is not registered. Yeah, but a lease, when you're leasing your land, you're basically entering into a contract with someone. And a contract is something that is entered into with the free consent of the other party. So in this situation, I think what you need to do is to come up with an agreement between you and the person you want to lease the land to. So that agreement will now be governed by the contract law. So you lease to them the land, they sign with whatever you've agreed on. The only issue is that you may not be able to get a leasehold title but it doesn't buy you from leasing your land by virtue of a drafted contract. That one you can lease it out, the person can use it and still pay you, but you may not be able to get a leasehold title, but you can still lease it out.
Thank you, Amy. Thank you, Irene. Thank you, Jordan.